interest, future and currently. When two clients' interests directly adverse, past, current, future and third parties deserve significant risk that representation will materially limited responsibility and also seriously exceptions to the conflicts of belief that is reasonable, not prohibited by law. Same two clients unbelievable. In California there's not no risk of limitation. Written disclosure needed if the parties are related. Lives with the party or is intimately felt. In Cali it's okay when insured insurer help. Former government employee may not represent your private if L participated personally, substantially, highly, unless L gets informed, consent and confirmed in writing. Conflicts get imputed to the law firm when you're fighting, unless conflict is personal or L is timely screened. Written notice former client or a waiver is seen. If L leaves okay unless the case substantially same and other L's behind are not confidentially stained. Compensation by third party when consent is informed. No interference, lawyer client confidential the norm. Opposing L a relative tell the client consent informed. L's personal beliefs plus a writing is strong. Sexual okay if pre-existing love. Don't need business transactions, only fair disclosure lovely. Terms fair and reasonable, advised to seek their counsel. Informed written consent in Cali, all disclosed in writing. A lawyer can't solicit client gifts when they're substantial. No instruments prepared unless relative of counsel. Cali undue influence advice by separate counsel. No proprietary interest unless lien for fees for counsel. Money ABA only advance or contingent. Court cost litigation or the client is impoverished. California loans okay if in writing it's established. No limits on malpractice, separate counsel, no impounding. To communicate properly, inform the client status of the case. Cali okay if harm another. Scope representation, L decides upon the strategy. Client substantive, jury trial offers pleas. Confidentiality, ABA cannot reveal unless informed consent or impliedly by the deal, or necessary to prevent death, substantial harm, crime, fraud with law comply, or lawyer is the pawn. Cali can't reveal unless death, substantial harm. Disclosure optional, dissuade, inform and then reveal. Attorney-client privilege, confidence, communications intended for professional service corporations. Client holds the privilege, ABA and after death. Cali estate settles, there's exceptions, catch a breath. Further crimes dispute with lawyer, Cali crimes prevent. Fee misunderstandings, ABA fees must be reasonable. Cali not unconscionable, misunderstanding limitations. Time, experience, length of time, nature, reputation, difficulty, novelty, custom of the paper. Cali fraud or overreaching, fee must be proportional. Fee agreements, how they calculate the nature of the service. Responsibility of parties in Cali, what they pay. Fee agreements found in writing unless corporations hang or previous client service similar or the client rates. Fee disputes, arbitration, California does require. ABA encourages but not compelled to by the wire. Fees that are contingent must be accomplished by a writing signed by the client and the lawyer if in Cali. Method and percent and expenses to deduct. No domestic criminal, Cali still negotiable. Fee splitting with non-lawyers always strict, always prohibited, but with other LOK consent in writing not inhibited. Fee splitting ABA okay, proportional and reasonable. Cali fees may not increase consent, written disclosure gives referral fees don't give value unless qualified. Cali past recommendations not exclusive is the alibi. Duty of competence and care, ABA skill and thoroughness. Knowledge preparation, California there's no recklessness. Not intentional repeatedly or negligently competent. Learning mental skill associate with someone competent. Duty of diligence, ABA diligence and promise. Cali intent no repeated and when negligence and promise. Safekeeping property, money separate. Trust account advances are withdrawn when earned. Cali one account and writing withdrawal is mandatory if there's violation of these rules. Mental physical conditions discharge Cali with harassment. Withdrawal can be permissive if using L for crime or fraud. Representation highly difficult, client feels or for the cause. ABA no materially adverse effect on client. Financial burden on the lawyer or the client is repugnant. In California, client can assent L's. Mental physical condition or continuing results in violation of what I'm spitting upon. Withdrawal, the lawyer shall give reasonable notice. Surrender papers, property, and any fees you haven't earned. Advertised solicitation can be lies or be misleading. Labeled as name and address, not directly client seated. In California, violation will likely be presumed if warranty or guarantee testimonial. No disclaimer, no fee without recovery unless client costs disclosed. No specialist if not approved, otherwise the lawyer's toast. You can't practice if not authorized. No partnering with heathens. Liability for other L if you supervise and lead it. Ratify or justify, you must mitigate the feeling. Duty of fairness, represented parties. Duty to the court, to the other side. No falsity for tamper with the goods. Return if inadvertently, yes, the lawyer should. In California, no, you can't pay for witness testimony. Don't influence the jury, judge, or out of court baloney. Prosecution must get the up to cheese defendant on the level. Violations you would then report and now adjust the treble. Duty to the public and profession for a crime. In Cali, no harassment threatened, this the PR rhyme.
Blind, it's mine. I grind, it's prime time. I grind, my mind. I grind, I climb.
Constitutional justice, ability, case or controversy, actual dispute, no political question, standing individual injury causation, plus redressability, third organization, member must have standing, notwithstanding valid purpose, parties not required or when taxes, souls and purses, ripe if not too early, if too late then the case is moot, 11th can't sue the state, damages the boot, state action when it's acted or tradition in a function, government entanglement substantially productive, Congress can't regulate commerce if interstate channels, instrumentalities, persons, things, activities, purely local economic, rational belief it's proper, substantial economic, correct, substantial economic beef, tax spend, naturalized, necessary, proper, rational belief if independence.
There's no burden but compelling and it's generally applicable. Don't establish, can't endorse or favor except gifts or incidental sex preference. Strict scrutiny plus a secular purpose must not inhibit or advance entanglement on the surface. First Amendment, free speech, content-based strict scrutiny, less protect obscenity, prurient interest, so offensive, lacks the values of society, misrepresent and defamation, lawlessness is imminent, fighting words upon the nation, content neutral, other fruitful, significant government interest, narrowly tailored, open channels for the interest, time, place, and manner, public designated spaces, viewpoint neutral is okay if the interest is significant, narrowly tailored, open channels available in the alternative if the floor is limited and restriction, viewpoint neutral, government interest is legitimate, reasonably fruitful, commercial speech on the beat, interest is substantial, directly it advances and is tailored to the narrow, this speech is symbolic, constitution has the power, unrelated to the speech, prohibited no more than necessary, free speech not vague, overbroad or unfettered, prior restraint, stop speech before it occurs, but the government can't do that unless seriously hurt, final determination and it's narrowly drawn, freedom to associate protected by when the interest is compelling and the least restrictive means, substantive due process, life, liberty, and things, fundamental strict scrutiny if not rationally related, procedural hearing counsel, call a witness to the stand, involuntary servitude was left behind, equal protection, different kinds, listen close to my rhyme, if discriminatory on its face, strict scrutiny applies, suspect classes, race, national origin applies, quasi-suspect gender based so the kid can't find the father, all others rationally related under legitimate cover, takings clause cannot take the property of another unless rationally related, public use, fair market value, total taking when it's permanent or no economic value, cause consider impact, expectations and delay before it shutters, regulatory taking character of the invasion, economic impact, interference with investment.
Climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb.
DJ, there's traditional consent, domicile service, modern law, armed statute up to constitutional limits, purposeful development and foreseeable for certain relatedness, essential, systematic, homey purpose, fairness, ways, convenience, and the interests of the person, subject matter, fed, questionful diversity of persons, where one is domiciled, corporations named and nervous, if unincorporated at the domicile of members, amount in controversy, more than 75,000, Cali subject matter, unlimited, more than 25, limited in small claims, 10K hop on the ride, supplemental jurisdiction, common nucleus of fact, same transaction or occurrence, now removal jurisdiction, defendant 30 days, max is 1 year when uncertain, remand can be had when removal isn't proper, venue claim arose, all defendants call their home, California NED resides, now venue definitions, people did as domicile, business, personal jurisdiction, Cali contract may perform breach agreement purpose, alternative right deemed subject to jurisdiction, transfer when original venue was correct or consent, if improper dismiss, transfer in Cali, go to proper county forum, not convenient interest, justice, public, private, notice, service, process, personal, and substituted. Cali, you must mail to only if person can't be made. Erie doctrine states substance for the feds, it is procedural. If unclear outcome, determinative balance of the conflict. California conflict, torts, comparative impairment. Contract choice of law or comparative impairment. Pleadings fed, notice, pleading California on the facts. Complaint identify the party, state the claim, and SMJ demand for judgment and a signature responses on their way. Motion more definitive, Cali at the mother. Motion to strike, anti-slap in California. 12B6, lack of SMJ, lack of PJ first response. Venue process service, all be made on first response. Failure to stay or join a claim when the party's indispensable. Cali general demurrer when the case is unlimited. Special demurrer when uncertain liability, lack of capacity. Another case resist misjoinder of the parties. Motion to quash lack of PJ or the process insufficient, and the answer must assert all affirmative defenses. Amend the pleadings as a right and the doctrine of relation. Same conduct or occurrence, California no amendments. Joiner is permissive or necessary when the parties know complete relief or interest harm. There are tons of obligations, but only join if there's PJ and diversity intact. If you can't join, court proceeds or dismisses cases whack. Impleader deacon add third party to the grind. Intervention non-party, interpleader land of mine. Counterclaim compulsory, same transaction or occurrence. Supplemental will extend, or the joiner is permissive. Supplemental won't extend if it's not the same transaction. Cross-claim against co-party, California cross-complaint class action. Fed requires commonality, numerosity, adequacy typically.
California ascertainable, let a member of community. Common questions, law of fact, adequate representation. Discovery mandatory, initial disclosures, expert information. Docs and pre-trial witnesses. Depositions, interrogatories, and requests for admission. Inspect, produce electronic, physical, mental conditions. If admissible, irrelevant, no attorney work product. Dismissal voluntary or involuntary, or there is no claim. Summary, no issue of material as a matter. Trial right to jury, fed legal, and then equity. County equity comes first and legal on the platter. Judgment as a matter, reasonable people can't equate. Trial renew motion only if you tried before. California directed verdict, you must file DV first. If appeal, final judgment unless collateral injunction. Now we finally move to the use of final judgments. Claim preclusion, final judgment in Cali when appeals exhausted. Same plaintiff, same defendant, same claim of final judgment. Issue preclusion, final judgment, and it must be on the merits. Issue litigated and essential to the judgment.
Blind, 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 it's mine, mine, mine. I grind, it's prime time. I grind, my mind, I grind, my blind,
Contracts, UCC when the goods in question movable. Otherwise the common law will dominate and immovable. Offer intent, definite terms communicated. Termination, counter offer, lapse of time and revocation. Firm offer irrevocable by a merchant, signed in writing. Option contracts, detrimental reliance on the promise. There's acceptance, unilateral, only accept with full performance. Mirror image, mailbox rule, acceptance is on dispatch. There's exceptions, offer says option, contract on receipt. If both acceptance and rejection, acceptance if receipt. Acceptance varies, you see, contradicting added terms. If both merchants added terms come in different terms, get struck away. Material alteration or objection within 10 days. UCC can fill the gaps, common law agree to terms. UCC accept by shipping, non-conforming is a breach. And if accommodation, counter offer on the lead. Consideration, no illusions and no pre-existing duties. Requirements, consideration, output, contract, equal duty. Promissory, estoppel, foreseeable, induce reliance. Count defense, deformation, marriage, real debt 1 year. Goods for more, $500 signed in writing by the affected. There's exceptions, merchant memo, but both must be merchants. One receives confirmation, both are bound unless objection or admission or estoppel or a misrepresentation, fraud, unconscionability, mistake, assumption, basic, materially affecting risk not assumed by party contract terms. There's performance conditions, strict compliance if constructive then substantial, or a waiver of conditions. Failure to insist compliance, keep the benefit unless reliance. Evidence, parole if a partial integration cannot contradict. Okay to supplement conditions, but if integration total, no words cannot.
Not to supplement the contract, but exceptions still exist. Subsequent communications or to show formation defects. Condition present, interpret an ambiguous condition. Modification if it's mutual, plus there's new consideration. UCC mutual assent, good faith, no consideration. Intended beneficiary can sue for the performance. Not intended cannot sue. Now we move on to assignment. You can transfer all the rights, no consideration required. Then the one who was assigned stands in the shoes acquired, but assignment is restricted if it material alters. Delegation, transfer duties, original still can be liable. Innovation, new performance, then release an obligation. Repudiation, unequivocal, won't perform before it's due. Non-repudiating party can suspend, discharge, or sue. Adequate assurance is reasonable grounds for insecurity. Must be in writing to suspend while waiting for the right assurance. Then there's breach, material minor, receive a benefit substantial. Extent of past performance, willful time not of the essence. UCC this perfect tender, accept the whole commercial units. If installments don't apply, it's substantially conformity. Seller's right to cure with the notice timely tender. Warranty express implied fitness for specific purpose. Fitness and good faith for dealings by the merchants. Substitute performance in a court that does not discharge. Satisfaction of performance and when it does so discharge. Contract offenses, there's no mutual assent or lacks consideration. Misrepresent, duress or fraud, undue influence, illegal, lack capacity, unconscionable, impossible.
Remedies, damages are limited, duty to mitigate and certain. Plus unless they are foreseeable and caused by other person. Expectations as if they perform, and there's consequential damages. Direct foreseeable, unique to plaintiff, now it's incidental damages. Expenses reasonable because the others breach of reliance, as if K not made now liquidated damages. Difficult to calculate, reasonable approximation. There's no punitive in contracts, quasi K derived a benefit. Replevant is for stuff and ejectment is for property rescission. Undue care, specific contract valid K conditions satisfied, and money damages inadequate. And it's feasibly enforced, no defenses, unclean latches.
Climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb.
Crime is assault, attempt to commit battery, or intent to place another, imminent fear of injury. Aggravated if deadly weapon, now we move to battery. Intentional or reckless causing injury. Offensive, aggravated deadly weapon, mayhem, permanent dismemberment. Kidnapping, confinement, move or conceal, secret place. Aggravated ransom crime, a child in the space. Rape, unlawful sexual intercourse, no spouse. No consent and gender neutral unto killing in its place. Murder is a lawful killing, malice shown in different ways. Intent to kill or grievous bodily injury takes place, or indifference that is reckless or a felony takes place. The result is naturally born during commission of a crime. Actual approximate causation must be found. Voluntary manslaughter, reasonably provoked, no time to cool off, did not cool, or imperfect self-defense. Manslaughter, involuntary when gross negligence takes place. Defendant disregards substantial danger in his face. First degree premeditated and deliberate is found. Second degree murder is first degree is never found. Sex crimes as larceny is a trespasser taken and carrying away with intent to steal from person. Embezzlement is fraud, conversion, and lawful possession. False pretenses is knowingly making a false representation. Past or present fact material causing convenience of the title. Robbery is larceny, property taken in their presence with force or fear, like when the Grinch steals children's presents. Extortion, threat of future harm, depriving stuff from owner. Theft, illegal taking of another's private bounty. Burglary is break and entering of the dwelling house at nighttime. Intent commit a felony, modernly it's in the daytime. Receipt of stolen property, the person receive, must be conceal, or dispose, intent deprive the owner. Arson, burn maliciously, dwelling of another. Modernly is all you see, structures or explosives. Now solicitation if encourage or request. Another with intent to do, and emerges with the crime. Conspiracy is two or more, agreement with intent to do. And you need an overt act to further what they do. Conspiracy does not merge, and withdrawal is a defense. Attempt is an intent to commit the crime at hand. When actions are affirmative and it emerges on the stand. Accomplice liability, principal commits the crime. Aids, abets, encourages to carry out the crime. Liable, additional, accessory, before and after. If no withdrawal, then liable, now defense is on the platter. Defensive of self when force is reasonable and proportional to harm. Defensive of others needs belief to stand and choose of others. Defend property when reasonable but no deadly force allowed. Insanity, mental disease, can't understand the wrong. Impulse, irresistible, unable to control. Conduct is a product of the illness in the man. Penal code capacity cannot appreciate the harm. Intoxication, voluntary, negates specific intent. Necessity is reasonable and needed to avoid imminent and greater harm to society as a whole. Mistake of fact negates intent of law is no defense. Factually impossible is not a valid claim. Legally impossible can accelerate.
Probable is a belief of crime that's reasonable and sound. Stop routine, just suspicion and checkpoints are allowed. Certainties or expectation of a privacy not found. Open fields versus curtilage, the courts will surely frown. Sensory enhancing and dog sniffing is okay. Warrants must be probable with neutral magistrate. Describe the person, things, knocking outs when on the way. There's exceptions to a warrant sealer, or when in plain view found. Presence is legitimate to take a look around. Car or cause that's probable unless police impound. Consent must be voluntary, no foul play is found. Destruction of the evidence or injury to person. Chasing you in hot pursuit or stopping first person. Terry stop is reasonable suspicion of the facts. Pat down for weapons allowed now on the random track. Right to silence and anything you say can be used against you. Right to counsel when custodial and interrogation lingers, likely to get incriminating and the suspect knows the question. Exception, public safety, 14 days since left the station. You can waiver voluntarily, knowingly intelligent. Right to counsel when invoked, unambiguous disease. Self-incrimination, testimony, evidence to seize. Double jeopardy, you can't be tried twice, same offense. Confessions voluntarily, over-suggestive when ID. Sixth Amendment, right to counsel before the charge or in a lineup. Sentencing but not epic handwriting or a fingerprint. Ineffectiveness of counsel when performance is deficient and results substantially different. The L who was deficient. Right to counsel deep and waive, now we move to confrontation. Adverse or hostile witness to compel trial or cross-examine. Only statements testimonial, but not an emergency. Right to jury for offenses that are serious in nature.
For 6 months, yes, the jury is impartial. Speedy trial, case by case, balancing the length and reason. Prejudice the key time and manner when asserted. There's exclusions, can't use evidence if found in violation. Plus the poison of the tree stemming from a violation. There's exceptions, independent source, inevitable discovery. But still can use it to impeach or in civil or grand jury. If the warrant is improper, then it is a violation. Evidence is not excluded if the cops act in good faith, except with lies, causes not probable, defective on its face. Confessions, no police coercion or an ID suggest plea bargains voluntary and no obligation vests. 8th Amendment right to bail, not excessive, really high. Court considers seriousness and evidence they find cruel, unusual. The penalty cannot be grossly high. Get them crazy and the victim statements are relative to bind.
Blind, it's mine. I grind, it's prime time. I grind, my mind. I grind, my blind.
Logic, relevance, proof, disprove, tally of disputed fact, legal provided and prejudice, balance in the act, proposition 8 in criminal defendant, opens doors, court may exclude on balancing, exclusionary rules, subsequent remedial measures are okay to show control, insurance liability, impeachment or control, medical expenses, free admissions may come in, but not in Cali, even sorry the admissions don't come in, offers to settle, or to plea, but under prop they may come in, California expression, sympathy accept admitting fault, witness knowledge must be personal, witnessing first-hand objections, unresponsive, arguing or led the way, compound question, assuming facts or a narrative is laid, to refresh the recollection, show an item to refresh, then W may testify from memory at best, lay opinion must be personal, no scientific special knowledge. Expert opinions, they must qualify opinion-based, okay. California, there is standards, highly tested, peer review. Attorney-client, confidential and professional is sought. Exceptions, further crime or fraud, dispute with lawyers hard. Doctor-patient, not the feds, but in California good. Spousal immunity during marriage, federal criminal. Only good communication, confidential during after marriage last. California, counselor, victim, clergy, penitent, news that blast. Character, evidence, reputation, or opinion-specific acts. If in civil, not for conduct, except when character at issue. Free accepts assault and child abuse or molestation, rape shield if its value is substantially outweighed, plaintiff reputation fine if plaintiff leads the way, California only prove plaintiff sexual consent, criminal character, the defendant must push open the door, traits must be pertinent, untruthfulness observed. Except the plaintiff can begin in a sexual assault, a defendant victim's character, prosecution can rebut, California there's exceptions when defendant shows the plaintiff violent character and prosecution can then match. Criminal court victims character, defendant opens doors, the character is pertinent and rape shield still applies. In the feds, D can offer that the victim first aggress. Prosecution can rebut that victim's peaceful like the rest. Defendant's character on direct that can't be specific acts. Put on cross they may rebut all 3 forms defendants passed. In California, no specific acts even to rebut. Victim's exam on direct, no specific acts to show. But on cross all 3 forms and prosecution can rebut. Rape shield, no reputation or opinions on the stand. Specific acts only for semen, third party injury. In fact, prior consent, okay in California, reasonable belief. Character, there's other purposes, intent to prepare, identify the perpetrator, knowledge of factor of event, absence of mistake or motive, opportunity, plan or scheme, habit, custom, similar, impeachment, now the scheme. First on cross, reputation, opinion, and specific acts, okay in California, if it's civil, specific acts are not allowed, but in criminal, the acts come in specific is allowed. Past convictions that are for falsity have a 10-year peak, misdemeanors not allowed, but in Cali it's Prop 8, prior inconsistent statement, extrinsic evidence allowed, also allowed when showing bias of the witness on the stand, sensory or mental defect, contradiction of another, the feds no bolstering the witness, California it's allowed, not hearsay, purpose, effect on listener's state of mind, independent legal significance, party admissions on the prowl, adoptive manifest, belief for vicariously heard.
In furtherance of the turd, medical purpose, diagnosis, but don't include the fault. In California, different story when child abuse at play, state of mind and existing mental or physical expressions, present sense and person describing an event or condition while perceiving or an utterance under stress, when the declarant was excited and startled by the event. If the witness is available, prior inconsistent statement, past recollection if recorded accurately when it was made, first-hand knowledge, fresh recording at the time the statement made, business record practice regular and recorder is a prize, business duty to report timely made when it arrives, public records learn writings when an agency records, unavailability disability means privilege, death, or illness. Can't procure a witness, refuses, or the witness can't remember. Former testimony comes if it's similar in interest. Tying declaration, imminent California death requires. There's exceptions for abuse, declaration against interest. You can forfeit doing wrong and residual exceptions. Now and document, establish relevance, and then authentication. Chain of title, demonstrate that it's a fair representation. Writing, recording, self-authenticating documents are present. Best evidence, the original and judicial notice. No dispute, generally known accurate determination.
Climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb. Torts, battery, intentional, causing harmful or offensive. Assault intent, causing apprehension, harmful contact. Emotional distress must be intentional or reckless. Extreme outrageous conduct, causing severe emotion stresses. False imprisonment, intentional confinement. Bounded area with no means to go plain if aware of the confinement. Trespass to land is unintentional physical invasion. If the chapel's interference with the person's use possession, there's conversion. If intrusion is substantial interference, defendant pays the value unless less intentional defenses. Consent expressed implied self-defense, reasonable force. Defensive property is properly prevent a looming tort. Recapture channel, fresh pursuit. Wrongful taking, level 4 shopkeeper's privilege. Temporary with belief the person stole. Defendant may restrain the plaintiff when exercising legal rights are reasonably necessary. Privately you pay for torts. Negligence of duty owed to a foreseeable plaintiff. With Andrews in is everyone a person reasonably prudent. Special duty caused the danger or you volunteered assistance. Professional and children, special landowner provisions. Children is intelligence, agent-like conditions. Professionals possess the skills and knowledge.
There's a breach if you fail to meet the normal standard care. Actual cause, but for test joint tort, substantial factor causes proximate when reasonably foreseeable. At first, eggshell skull as you found them unless causes intervene. Damages actual injury, duty to mitigate an IED physical injury. Zone of danger must be met. Partial comparative bars recovery if negligence is more than D. If it's purely then in proportion to the fault. Assume the risk is a defense, strict liability. We move animals, trespass, wild, domestic if it's known. Ultra hazardous activities, high risk of serious harm. Can't reasonably eliminate benefit versus harm. Products liability, 5 theories you can use. Strict commercial, place the product in stream of commerce way. And product is defectively designed, or when it's made still show actual and approximate. And where the damage lies, warranties express implied and fit for single purpose. Intentionally misrepresent and harm substantially certain. Out of product and out of fraud and false representations. Misrepresent knowing reckless intent. In duty objectionable to persons in the normal course of nature. There's false light, public placement also highly objectionable. Publicity and private life publicized with private details. Misuse of processes, malicious prosecution for the plaintiff. No probable cause and proper purpose. Damages, abuse of process, wrongful use, ulterior motive, willful act in wrongful manner. Interference with the business one knows and interferes. Defense, privilege, competition away from damages you steer. Third parties yes vicariously within scope of the employment. Defendants join in severally, contribution and indemnity. Survival rights, wrongful death, next of kin can recover. Interfere with family, consortium, service of another. Improper purpose, damages, abusive process, wrongful use, ulterior motive, willful act in wrongful manner. Interference with the business when knows and interferes. Defense, privilege, competition away from damages you steer. Third parties yes vicariously within scope of the employment. Defendants join in severally, contribution and indemnity. Survival rights, wrongful death, next of kin who can recover. Interfere with family, consortium, service of another.
Blind, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb. I climb. Remedies, damages for torts. Causation and foreseeable. Certainty, avoid general. Non-economic, suffer pain. Special, medical bills and lost wage. Past and future losses may also be obtained. Purely economic, are generally restrained. Unless property or injury or business interfere. Straight on with the bar exam, I will have no fear. Tort, constructive trust, wrongful act. Legal title to convey an inadequate cash. Same thing equitably, and know what I mean. Damages to speculate, insolvency. Injunction, TRO, irreparable harm. Likely to succeed, inadequate charm. Balance Balancing of hardship, no defenses to apply. Latches on clean hands, now let's go for a ride. Injunction that's preliminary, likely to succeed. Remedy inadequate, balancing the need. Permanent injunction, inadequate still. Property interest, feasibility kills. Balancing of hardships, no defenses that attach. Unclean hands or defenses of a latch. Contract, expectation damages first. Damage limitations, causation will lurk. Unavoidable, foreseeable, and certainly known. Liquidated clauses are known to control. Consequential, incidental, or rely on the promise. Liquidate if difficult to calculate dollars. Reasonable relationship, no punitive pain. Quasi-contract restitution, repleveness for chattel. Executive land illusion, rescission if invalid. Reform, rewrite latches hands, I'm going back to Cali.
Climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb.
Actual possession, open notorious. Hostile, no consent, continue the story. Land sale contract, apply statute of frauds. Parties, identity, signed by the frog. Describe the land, consider it, some SOF exceptions. Possession for improvements, payment in connection. Marketable title, and remedies for breach. Money or performance, specific to reach. Mortgage and foreclosure, priority norms. Senior, junior lender, priority storms. A valid deed requires parties in a writing, signed by the grantor, describing all the bounty. Words of intent, no consideration needed. 3 types of deeds, quick claim, there's no bleeding. General precise and owner owns what he pleading. Right to convey, no encumbrance in front. Title quiet, use enjoyment, and further we go. Deed delivery intent, transfer and acceptance. Merger contract merges, but the deed controls. Damages is purchase price or difference, you know. Defenses latches on clean hands or waiver to show. Recording acts protect a buyer with the dough. Take for value, no notice, does not actually know. Actual record, inquire, shelter the flow. Fee simple, fee tails and life estates. Future interest, there's reverter and right to parlay. Reversion and remainder, vested contingent. Executory interest, shifting and swinging. No restraint from alienation, you already know. Rap 21 years, must vest or know before. Joint tenancy in common, right to the whole. Joint tenant, right survivor, T-tip on the go. Not severed by a will, many attempt is void. Lien theory does not sever, title doesn't know. Tenancy in common, unequal shares is fine. They sell gift or will, no right to survive. Tenancy by the entirety, spouses alone. Right to survivorship, until death or divorce. There's accounting but improvements, no rights to the cash. For betters where necessary, offers rights to get back. Landlord-tenant terms of years are periodic. Duty to pay rent, and the tenant has the object. Condition of the premises, quiet is best. Constructive uninhabited, no option is left. Substantial interference, and notice is given. Landlord don't respond, time you leave when it's given. Warranty to habitats, terminate and move, repair, deduct or rent reduce. No retaliate but sue. Tenant cannot cause waste, decrease or neglect. Fixtures, attachment fit, remove intent of the deal. Assignment yes, landlord sue. Sublease only rent is due. Easements can't affirm the gate. Appurtenant is land, dominant receives the gift. The servant carries burden, engrossed to a person. No land rights a burden. Easements by express or implication when it's certain. Necessary strictly, no prior use prescription,
required.
actual use, open and notorious. Hostile consent, continuous is glorious. Servant owner not required, dominant maintains. Termination by estoppel or necessity wins. Destruction, condemnation, abandon, release. Merger of the parcels or prescription relieves. Real covenants a promise, if burden runs with land. Writing is required with intent in the hand. Touches and concerns, vertical and horizontal. Privity and notice if benefit, no horizontal. Equitable servitude, restrictions on its use. Writing in intent and then touch concern anew. No privity required, but a notice should be given. Terminate like easements or substantial change conditions. Profit take from land and a license is permission. Zoning, public health or safety variance the mission.
Climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb. I climb, it's mine. I rhyme, it's prime time. I grind, my mind. I rhyme, I climb.